we're excited to have this conversation between Professors Walsh and Kerr. We will have some time for questions. And what I would encourage everyone to do is if you have questions, just to type them directly into the chat box. And Professor Walsh will be fielding those both, as they pop up through the conversation, but also towards the end. So with all of that housekeeping taken care of, I'd first like to introduce two other special guests that we have with us this afternoon, two young members of the mock trial program at Henrico High School. Caio Burgess is a junior and is a member of the mock trial program. He is the chair of logistics. And Faith Dixon is a senior at Henrico High, and she is the chair of the entire mock trial program. So we're really excited to have them on board to introduce a fellow mock trial alum. So I'm going to turn things over to Caio and Faith.
Yeah, so good morning. Good afternoon rather. My name is Caio Burgess. I'm, as Caroline said, the logistics chair.
Hi, I'm Faith Dixon, and I'm the head chair of mock trial at Henrico High School, and I'm a senior.
So the John Marshall Center is a proud partner of the Virginia Law Related Education Institute, which sponsors mock trial programs like ours. If you're interested in learning more about mock trial programs or would like information about starting a mock trial team, visit the John Marshall Center website at johnmarshallcenter.com or .org rather.
We're excited to introduce this afternoon's installment of the Marshall Scholar Series. In today's program, Professor Kevin C. Walsh, University of Richmond School of Law, and Professor Orrin S. Kerr, UC Berkeley School of Law, will explore whether the government compels someone to unlock or decrypt a phone or a digital device by looking back at the 1807 trial of Aaron Burr.
Let's turn it over to
Professor
Kevin Walsh.
All right, thank you so much, guys, and welcome. Mock trial was one of my favorite things in high school, and well, I wish you all the best. Orrin, did you ever do mock trial?
I had some trials that were mocked, I think, but never did mock trials.
Got it. Well, let me give it just a brief introduction to everyone to Orrin for everyone's benefit. Orrin and I go back, I don't know, to like 2003, 2004, when we were both clerks. Orrin was a law clerk for Justice Kennedy, but he sort of impressed all the rest of us because he was a law professor before that. And before that, he was in DOJ. So he had a lot on us neophytes. But we had a good year, and he went back into the academy, was at GW. And then he was stolen by Berkeley. And now he is out on the West Coast teaching criminal procedure and writing about constitutional criminal procedure and all manner of things. I think I first knew him for his computer crimes casebook. And I recommend you all follow him on Twitter for updates on sort of all sorts of things related to the law. He doesn't just teach law, he practices it. He's filed some important amicus briefs. He's testified before Congress. He's argued cases in the Supreme Court and in the federal circuit. So we're in for a real treat today because what we're going to talk about, it kind of stems out of this article in the Harvard Law Review. Now, all of us law professors would love to publish in the Harvard Law Review, and I hadn't gotten past my student note, which was a fine note, but you get into Harvard Law Review, you did something right. And Orrin's article is called "Decrypting Originalism: The Lessons of Burr," and it was published earlier this year. Now, he wrote it probably even a little longer ago because it takes a while to get through the publication process, but it takes us all the way back to 1807. In 1807, there was the trial of the century for the 19th century. The population of Richmond doubled at the time. And the main event was the treason trial of Aaron Burr. And it actually stretched out over a couple of months because you had some grand jury proceedings. Then the grand jury ended up saying, yep, in fact, we're going to return, we're going to set him up on charges for treason, which was a capital offense, as well as a violation of the Neutrality Act. So where did that all come from? Well, Aaron Burr left New York in disgrace, and then he left Washington at the end of his vice presidency, and he went west. And what he was doing is unclear. We do know that he was organizing a band of men. They had arms. It was unclear, though, whether he was going to separate the Trans-Allegheny West from the United States, or whether he was just going to be a peaceful farmer on the Bastrop Tract. But we do know that he engaged in some machinations. He did, he conspired in certain ways. But when he was arrested, okay, it's because President Thomas Jefferson was convinced, and he said it to the nation, that Aaron Burr had treasonous intentions out west. And part of this came from evidence from who may have been a co-conspirator, we're not sure, General James Wilkinson. Wilkinson had communicated with Burr in cipher letters, which we'll talk more about ciphers. Burr had communicated with a lot of other people in cipher letters, including Dr. Eric Boldman and Samuel Swartwout, who were alleged co-conspirators in this treason trial. Well, that sets us up. So Jefferson was convinced after Wilkinson turned or whatever he did, and Aaron Burr was on trial for his life in the city of Richmond. Why, though, are we talking about this today? We have a narrower focus. It's not about the law of treason. Our focus today is the law of compelled self-incrimination. And this comes out with lessons for the present, for decryption of digital devices and things like that. So let's get started to hear from Professor Kerr. Oren, help us understand, here we are in 2021, you had this law review article published that goes into great detail about one piece of this long ago trial. What possible relevance, right, does this narrow question about compelled self-incrimination from a cipher letter in the testimony of Burr's secretary? Why are we here?
Yeah, good question. And I should say, I'm not a trained legal historian. I love legal history, and I've written a couple articles on legal history. But my real interest is in digital evidence and in computer crime cases. I do a lot of what are the rules if the government wants to search your cell phone or access your email, or search your laptop. That's kind of my interest. And I've been following for 20 years now a really interesting question of what happens if the government wants to make you unlock your device. They have a search warrant to search your phone or your laptop. But it turns out by default, a lot of these devices are locked with very sophisticated encryption. And the best example is probably almost everyone here has a cell phone that locks by default. And so you've got your code that you have to enter in. And it's not just a little code. What that's actually doing, modern cell phones are remarkably sophisticated tools. All of the data on your cell phone is scrambled, that is encrypted, with a very sophisticated encryption mathematical algorithm. And if the code is not entered in, it's just garbage. It's just zeros and ones that make no sense. It's not actual sort of information. And you need that code or some way of bypassing the encryption in order to gain access to the device. So this was sort of an interesting question 20 years ago when once in a while a sophisticated computer hacker would have encrypted his desktop computer or something like that. Well, in the last 5 or 10 years, it's become a completely routine aspect of many criminal cases because most people are carrying cell phones. And cell phones, by default, have this very sophisticated encryption on them. So this question of, well, can the government make you hand over your password? And that can come up in a couple different ways. Can they make you state your password or your passcode, like the numbers to enter in that normally people enter in to unlock their phones? Or can they make you enter it in without telling them the passcode? Or in some cases, can they use compel biometrics, like a thumbprint or an eye reader, to make you get past your encryption? So the way it comes up in modern cases is the government needs a search warrant to search the device, but they can't search the device because the device is locked. And what's the best way of unlocking the device? Well, One way the government can try to unlock the device is by getting the person who uses the device to unlock it for them. And so what happens is the government will say, all right, cell phone owner, unlock your phone or tell us your passcode. And the person will say, no, I plead the Fifth Amendment. I have a Fifth Amendment right against self-incrimination. You can't make me help you by making me testify. And then I'm really testifying if you make me speak my passcode or do the act of entering in the passcode.
So
let
me jump in there, Oren. We know it from television, right? People say, I plead the Fifth, right? I plead the Fifth. And so I get how it would be like testifying or somehow kind of like you making me state something. Government, you can't, right? But isn't there a part that it has to be incriminating, right? Like my passwords might be like embarrassing or random or weird, but usually they're not. The passwords themselves are not, like criminal for me to state. So like, how does this tie into? So when someone says I plead the Fifth for my password, I get the testimony part, but don't they have a problem with the incrimination piece of it?
And it depends on what you think incriminating means. And so this is something where there's a lot of U.S. Supreme Court case law over the last 200 years kind of trying to figure out what incriminating means. And one of the big questions is, do you take a causal approach to incriminating? So the government does not care in these cases what the person's passcode actually is. They just want to get to the data on the device that the passcode is needed to unlock, to gain access to. And so this is equally true whether they ask for the passcode or even if they just say enter in the passcode. In that case, the government never even learns what the passcode is. All they know is that the device is unlocked, and then they can search the device based on the search warrant. So one of the questions is, what does incriminating mean? And modern cases suggest when it's a statement, incriminating includes a causal relation. So it may be that the thing I tell you is itself innocent, but if it can be used to learn something incriminating about me, then I still have the privilege, and it's an incriminating thing. Then there's the question of what happens when it's an act that's compelled. So if you don't make me say my passcode, but just make me enter it, is that testimony? Because I'm not saying anything, I'm only doing something. And there's Supreme Court cases that have answered how to apply the Fifth Amendment privilege to compelled acts, and how do you know what the testimony is implicit in an act, and how do you apply the incrimination test? So there's a lot of current case law, and what drew me to this problem, sort of how I got here, was I wanted to think about how the Supreme Court should answer this question, because lower courts have divided on it. And as Kevin, as you know, when state Supreme Courts and federal circuit courts disagree, that creates, they call it a split, and that usually is what prompts the U.S. Supreme Court to decide a case. So lower courts are hopelessly divided on this question of how the law should apply, both in the setting of compelled disclosure of the password and in compelled entry of the passcode. And so I'd written an article on how I think current law should apply. And I started to think about, well, what would the U.S. Supreme Court actually do? And then I realized there's a good chance they wouldn't follow current law and they would do something else. And that's what led me to this article.
I see. Okay. So yeah, let's bring this now to Burr, right? Because this is, so far you have a great setup for a great law review article, right? Which is identify a problem that the lower courts are having difficulty with, understand that the Supreme Court is likely to be looking for guidance, recognize that there's some tensions in the current doctrine, even at the Supreme Court itself. And that last piece, just to fill in, right? You say, well, I suspect they might not be such big fans of their current precedent. And in part, as you and I know, that's because a number of the judges are self-professed originalists that look to the original meaning of constitutional provisions. In this case, we'd be talking, or in this issue, we'd be talking about the original meaning of the Fifth Amendment ratified in 1791. Okay, so now let's locate this in 1807. So here you are, you have this setup, you have this issue, and you realize, and you've realized this in prior writing, but you decide to dig in. You say, actually, this thing happened in the Burr trial. And so now let's introduce Charles Willey, right? So Charles Willey is a secretary for Burr. And then there's another guy named Eric Bowman, who is a alleged co-conspirator. And in these grand jury proceedings, it turns out that there is a cipher letter From Burr, we think, to Bowman. And we'll put Bowman to the side because it turns out there were some complicated issues about getting him to testify, involving a little bit of strong arming by Jefferson, but we may come back to that. But so if we want to know about this cipher letter and Bowman's out of the question, Burr, he'd be the main event. We might want to go for him later on. But Willie comes in, and the thought is that Willie, as the secretary, copied this cipher letter. And so two questions that we'd set up is, what did they what did they want from this guy Willie? That is the prosecutors. What did they want from Willie? And why did he say no when they said asked him for what they wanted?
Yeah, so the main thing they wanted is for Willie to authenticate the letter. Like, what is this letter? This is a cipher letter, and it turns out Aaron Burr wrote a lot of letters in cipher. In fact, when he was in college, he wrote to his family in cipher. He was really interested, and this was common in an era when letters could easily be intercepted and read. It was common to come up with some sort of code that you and the recipient would know that the person trying to read the letter wouldn't know, so you'd be able to basically encrypt your letters. And there was an encrypted letter believed to be between Burr and Bowman, and the government wanted Willie, they basically asked him to say, do you understand what's in this letter? Tell us if you understand what's in this letter. What they didn't actually ask him what is the letter, testify to the contents of it, but they asked him, do you know what's in the letter, basically to authenticate it. And it was going to be Bowman who actually was going to say what the letter was about. But if they'd asked Willie, do you know the contents of the letter, they might have then asked him, well, what's in it? And so Willie said, I invoke my privilege against self-incrimination. You can't make me testify about whether I know what's in the letter. And his main reason was, if you make me testify about what's in the letter, then I am potentially admitting my involvement in either the plot or some violation of the Neutrality Act, where one of the crimes here is misprision of treason. It's a crime to hide a treason. And if in fact the letter said, like, let's commit treason, and it turns out Willie knew that, then by not reporting the treason, he would have committed a crime. And so he's basically saying, you can't make me testify because I'm putting myself in legal jeopardy if it turns out that I do know the answer to this and I do know what's going on with this letter, and you can't make me. That's incriminating.
Okay, good. So let me. I'm going to put up, I think. So what we're looking at here, I think on my screen is from your article. This is an example of a cipher letter, right? And so what we see on the left is the letter, right? So there's some words, and then there's just like numbers and these weird signs. And then over on the right, we have the cipher alphabet, right? So this is sort of like the decoder, right? And so what we're basically saying is, if I understand it, is that we have this weird looking letter thing. But just looking at it, it's like the ones and zeros on the cell phone that has that's just sort of, it's gobbledygook, and we need some information from this witness or this person or someone who may know. And it might just be, do you even know how to unlock this particular letter or decrypt this particular letter? And he says, whoa, no way. I'm not even saying anything about that letter. Not even whether I know what it is, and that's where kind of things stop for the day, right? So then I should add the reason that Orrin was able to make such good use of everything that happened in these arguments is that this, as the trial of the century, this was the proceedings were very carefully transcribed, brought down in shorthand, and reported. And so, Orrin, you worked from the reports, and then there have been other scholarship. So they stop for the day, and then the lawyers come back, and Marshall, who is presiding as a trial judge, because that's what Supreme Court's justices did in certain circumstances. Marshall, as a trial judge, says, okay, we're going to hear arguments tomorrow, or we're going to take a break, and when we come back, right, I have some questions for you all, and I'm going to want the answers to these particular questions. And the questions really are, who decides what's incriminating, right? So Willie says, I'm not even saying anything about this letter. What letter? So one is sort of who decides that particular question. How directly must he kind of say this will incriminate me before he can go? The second question, that was one question. Another question was, who makes the decision about whether the witness, just needs to go forward, period. And then the third is just applying sort of these things to the facts, right? So let's break it. So my formulations can be improved. So let's start with this one. The first question is, who decides whether answering the question might oblige the witness to incriminate himself, right? So who decides that question? Because one answer might just be the witness just says it and that's it. We just have to take the witness's word, but it's hard to see what the other side is. So what does Marshall say about that one?
Marshall says it's ultimately up to the judge to decide whether the issue's in play. It can't just be a witness says, I invoke my privilege against self-incrimination, and then it all stops. There has to be kind of a good reason to think from the judge, from the external circumstances. So the judge doesn't know what the person is actually thinking or what they might say, but the judge makes this assessment of whether it's plausible that that's the case. And that is, in fact, current law. So that was actually that first ruling in the Burr opinion, which the lawyers argued about it at great length, is actually Chief Justice Marshall settling what became the legal standard for invoking the Fifth Amendment privilege. It's kind of amazing. And that he worked from these historical materials. What made this kind of really fun as an article to write is that it turns out we had this transcript, as Kevin, as you mentioned, that the ultimate issue was never focused on by lawyers or historians because it doesn't really go anywhere. It turns out that Willie's testimony, he ultimately is told he has to testify, but his testimony is like totally uninteresting. So this long hours probably of discussion and debate between the finest lawyers of the day before the Chief Justice of the United States gets forgotten because it kind of like didn't go anywhere interesting. But it's hours of advocacy invoking, not only did the lawyers mention, cite cases and cite treatises, they cited pin cites, so pages. It was like really, really detailed lawyering by really the finest lawyers of the day, the most prominent lawyers of the day. But they actually did not have a lot on this initial question, which was who decides. And the reason they didn't have a lot is that the way this had come up at common law, this is mostly in like 17th century cases involving a witness who might be testifying as to being Catholic or knowing Catholics or living with Catholics, which at the time could expose you to criminal liability in England in 1689. And so the judge would step in and say, like, be careful. So the defense typically would be asking the question, did you live in the monastery? And the judge would say, wait a minute, to the witness, don't answer that question. You don't have to answer it if it would incriminate you. And so it had mostly come up with judicial interventions to defense witnesses. And that didn't raise, when the judge is sort of making the intervention, it's not even the witness saying I won't testify. And so this raised the question, well, what happens if it is the witness testifying? There actually just wasn't a lot of this. So Justice Marshall, his Burr opinion is remarkable. If you look at all the historical materials that he had, he really put together, I think, a very thoughtful package of working through the issues and sort of reasoning through them. And his answer to who invokes the right or who gets to decide it is still the law today, this many years later.
So Willie's first kind of line is like, I said it, that's enough. And so you just have to take my word for it. He doesn't prevail on that, right? But then we still are like, okay, well, what is it that you then can be allowed not to say, right? How must it relate to this question of guilt? And so on the second question is sort of the standard for self-incrimination, right? How directly might the answer to a particular question come in? And on this, the prosecution is saying, look, unless the answer itself will show that you're guilty of some crime, you got to answer it, right? And Willie, of course, says, hold on, look, the way this works, crime, usually it's not just like one set of words or one piece of information. You're building a case, you're building it methodically, you're putting together a chain, connecting the facts to the elements and ultimately trying to convict me. And I don't have to give anything if it's any link at all in the chain, or there's even maybe broader ways of formulating it. But how does Marshall come down on sort of this directness of the relationship between the answer and the crime? How does that one come down?
So Marshall basically agrees with the defense on that one.
Okay, so he wins this one. Okay.
So yeah, so he after the government wins the first part, the defense wins the second part, and he says it can't just be that you confess to the entire crime. It'd be too easy to craft a question where you're admitting to most of the crime but not all the crime, and then the privilege wouldn't mean anything. So it has to be that it's an essential link in the chain. So it has to be an essential link, but it has to be, and it's a piece of liability, but it doesn't have to be entire liability. And that essential link in the chain language, which actually came from a case the earlier year, a case called Goosley. It actually had been used in this earlier case. But Marshall adopts it, and that is in fact still used today. That language from Chief Justice Marshall in 1807, that Burr opinion ends up being relied upon in Supreme Court cases in the 19th century, and it actually, that language is still used today, although it ends up applied differently today than it did in Marshall's time.
Okay, good. So we have the judge decides, but the defendant doesn't then have to answer if it would provide a link in the chain. And then we'll go into some other applications, and we'll kind of skip the third question, and not skip, but we'll just kind of just go right to it, because it turns out that even though that was a pro-defendant ruling, right, on sort of how directly it needed to incriminate him, the third question or the third issue was, okay, now let's apply these two things to the facts here. And ultimately, Marshall says, remind me what that question was that you refused to answer, right? And it turns out the question was just something like, do you currently understand this letter? And Marshall said, let's think about that. If you currently understand, so this letter, even if it has all this plotting and bad stuff related to treason, currently knowing it, maybe you found out about it yesterday. Maybe you, so he ends up saying, all right, Willie, like, answer the question whether you know it now, because that doesn't say anything about sort of the stuff in the past, right? So Willie then takes the stand, and then they say, did Aaron Burr write this letter? Did you, and he's like, well, not answering. And they kind of take a break, and they adjourn, and more or less Willie's done. He authenticated in some ways that at least the secretary currently knew the letter. And so it ends up being a side issue in the case, but because they argued it so much, right, you're able to sort of extract different things. So let's talk a little bit about sort of what authorities they relied on. So when we say, oh, go look at the arguments of the lawyers of the day and of the decisions of Chief Justice Marshall in this case, they will help you not necessarily because of this particular case, but because they show you how to argue, or at least how lawyers in 1807 would argue about the meaning of the Fifth Amendment. So what sources did they end up relying on, right? You said there was only one recent case from the US. How would a sort of good lawyer of 1807 look to the meaning of this 1791 provision?
Yeah, the key thing frames all of this is that they saw the privilege against self-incrimination as the same as the common law privilege against self-incrimination that had been flagged in treatises like Hawkins' treatise going back to 1721, and had been seen in a couple of major treason cases from the 17th century. These are the Catholic cases that I mentioned earlier. And it wasn't a huge part of criminal procedure in the common law, but all of the discussion proceeds on both sides with the assumption that we're really talking about the common law privilege. You look to English treatises on evidence law and when questions are allowed, what privilege against self-incrimination means there. So it's primarily a discussion. There's a little bit of discussion of U.S. case law that had been very fresh, like a year or two old, but most of the discussion is on these. There was a treatise by a Dublin lawyer named Leonard McNally, which summarized a bunch of cases mostly from the 17th century. There was discussion of Hawkins' treatise from 1721. And then there was discussion of the state's trials cases, which was basically the report of English major trials for treason, which is where this issue had initially come up. And then there was an index in 1787 to which cases involved this trial. So they're basically looking at English history, treating it as the same as the U.S. privilege. And in fact, they treat all of the pre-Revolutionary War, or at least pre-Constitution English cases as binding. And it's only when they start talking about U.S. cases, or there was one, I think, 1791 English case, where they're like, well, that's after the Revolution, that doesn't really count. So they seem to base it, the concept was that this privilege against self-incrimination in the Fifth Amendment is this English common law privilege, and it is whatever it meant at the time of the Revolution and was sort of brought over to U.S. shores. And so if you want to know what the privilege against self-incrimination means in 1807 or in 1791, you're asking what this English common law privilege meant. So much to the point where there's a separate section in the article where you have to kind of make sure, wait a minute, were they actually applying the Fifth Amendment, and were they not applying just the common law privilege? Like, how they never actually talk about the Fifth Amendment. They don't do what modern originalist thinking would be, which is like, let's read the words and come up with what these words mean. They go straight to the English common law, both sides.
Right. Yeah. So this is super important, because a lot of times when we think about originalism, right, and we tell a story about how originalism, as which is a dominant approach in some respects on the current court, but not in others. But when we talk about originalism, it's often thought that when we look for the original public meaning of something like the Fifth Amendment, that calls for a kind of linguistic or semantic analysis, right, to figure out what would an ordinary person, or what would, well, there's different ways of putting the ordinary thing, but what you're saying is that the legal meaning for the lawyers here was not so much a question of parsing semantic, linguistic content, but treating the words of the Fifth Amendment as a pointer in some ways to a body of law and a set of principles that pre-exist the Constitution.
And I think this explains why there's like no discussion of the specific words of the Bill of Rights that are sort of these legal concepts. Like I do a lot of Fourth Amendment law, and it's really, really frustrating that from a Fourth Amendment standpoint, there's no discussion of the text of the Fourth Amendment, of what exactly this word meant, what did that word mean, and similarly the Fifth Amendment privilege. Virginia had proposed that there be a federal Bill of Rights, and this committee that Virginia of Virginia sort of leaders that had proposed this. And in fact, it included John Marshall, and it included Edmund Randolph, who's one of the defense lawyers in the Burr case. And so it's all of these leading people, and there's like slightly different language every time it's proposed. From a modern originalist standpoint, it's like, well, wait a minute, they're using different words. They should be thinking about the different meaning of these words. But the suggestion what I would suggest from my reading of the Burr materials is that they knew what it meant, which was they were lawyers. They were lawyers that had a concept of English legal rights. And the Bill of Rights was like, we want those English rights. We want that thing which pre-exists, and we're bringing it here. So it makes sense they didn't focus on the specific words, because it's the pointer, as you mentioned. It's not a new idea, it's an old idea.
So this, just to switch over to another area for a second, so with this work, so if we were trying to figure out the Second Amendment, so right, the Supreme Court is hearing a case this term about this case called Heller, where they said, well, there's a right to possess a gun for self-defense in one's own home. And now they're deciding, does that extend outside the home and things like that? Would the analogous inquiry be into, well, what was this right to self-defense and how did it relate to the bearing of arms under English law? Is that sort of an analogy?
Yeah, I think so. I mean, and you'd have to look amendment by amendment to make sure that they were just trying to do this sort of, pointer rather than trying to do something new. And some of them, like, the First Amendment, Congress shall not enact. Obviously, that they were thinking of something new to some extent there. So some of them are new, some of them are not. But they're lawyers.
Right. So sort of like
a legal culture, and they have legal concepts that they're talking about.
So originalism, there's lots of different ways depending on how the original law in some ways was formulated. And in this case, it was carryover from this sort of well-developed. Okay, so this sounds a little bit daunting for lawyers today, right? So a lawyer is representing someone and the government has seized the client's laptop or the client's cell phone or something like that. The government now seeks to compel the defendant to disclose the password. And what question do we ask first, right? We don't say like, get me my Hawkins, right? Get me McNally. We have this into some workable legal rules. And so after doing all of this, you in your article, you come up with a sort of 3 different scenarios. And so like the first scenario, let's just say the government is trying to get evidence for something, right? So kind of close to Burr. It's sort of you have this gobbledygook that is this sort of information. I just need to unlock it somehow to get evidence. And I need your password. How do the lessons of Burr sort of apply there?
Yeah. So before I get there, let me just add a step here, which is that it's totally plausible, possible, fine to say this history is really interesting, but we either don't think it resolves with enough certainty how the law should apply, or we don't think that following that exact meaning is the way to go today. And so this article does not make I'm not arguing that you should be an originalist. I'm not arguing like those are all those big questions. And when I was workshopping this paper, people were like, well, are you arguing for originalism or not originalism? I'm like, I have no position on this. I'm just saying that if you want to be an originalist and you really want to take it seriously, here's where it seems to go. And so I come up with kind of my set. I put on my 1807 lawyer hat. I've just read the Burr case and I'm familiar with the Burr dispute. And then I'm given these new 20th century or 21st century facts. What do you do without any sense of like, this is what you should do? This is just, I think, where it points. And where I think it points is that if the government is seeking evidence in a case, they can compel the password because the password itself is not incriminating. The password itself is not evidence. It's causally related to what is incriminating. What's incriminating is the information that's actually on the phone. So basically the password is just a gate to get to some sort of treasure, evidence treasure that the government is seeking. And so there's like a door there and the passcode opens the door. And so in a case where the government is seeking evidence, like let's say it's tax fraud records or something like that. They want to make sure, they want to show that the person was committing tax fraud by showing he had fraudulent records or an email that said, let's commit fraud on an email. In that case, the passcode, although it's a way of getting to the evidence, the passcode is itself not evidence. In the same way that with Willie saying, do you know what is, do you understand this cipher? Do you know what this letter says? That was not incriminating. There were ways of interpreting the question in a way that did not actually confess to part of the crime. And similarly, the fact that you know how to unlock the phone is not actually confessing to the crime. It's just providing a causal link. And so I think the lesson, if you're going to get really into the Burr case and say, what does Burr tell us about the original public meaning of the Fifth Amendment? A big part of it is that their concept of incriminating was about how much evidence you're forced to tell that is evidence of a crime, not whether you're forced to say things which causally lead to the discovery of such evidence.
So on that, right, and this is getting beyond sort of my grasp of criminal procedure, but my understanding is that modern doctrine, right, in some ways allows for a causal type of argument to be made. In other words, that under modern doctrine, maybe the privilege is wider, because you can kind of say, whoa, look at all the, you can't make me do this because of what it might lead to, just causally, just as a matter of fact. And if that's correct, then it sounds like that, at least on this question, the original meaning sort of is more favorable to the government or less favorable to the privilege. Is that right?
On this particular question, yes, I think that's right. It's all overall, it's I think a mixed bag. And where the Burr case goes is actually it goes in some weird directions. I should say it's sort of an odd rule that seems to emerge from the concept of incriminating that the government or that John Marshall had in the Burr case. But keep going. We got more scenarios to.
So then, like on the other side, right? So that's like when they're looking for evidence and they're like, we need your business records or something like that. But and we just the records themselves, they're just records. Assuming they're accurate, they might have a mismatch with what you filed in your taxes, but your records are your records, and we just want files on the computer, and it's just evidence we're looking for. But you break out separately this category of contraband, and you talk about compelled disclosure for contraband cases. So what is contraband? Why is it different from mere evidence? And then what lesson does Burr offer there?
Yeah, so contraband is basically a legal category of things which are illegal to possess or distribute or import or export, and it would be drugs, for example, or in the digital setting, child sexual abuse material, child pornography, where it's illegal to possess the image itself, and the government wants to get into the device in order to prove possession of the image, and possession would generally be defined as knowing control over the image. So you have control over it, and it's there, and you have control over it. That's usually what possession means. And it seems to me, taking Burr seriously, that the defense should have a good argument in a contraband case that saying what the passcode is actually revealing an element of the crime. It's giving the government direct information that is part of the crime, because when you admit the passcode, you're admitting that you have control over the device. And if you have control over the device, you're helping to show, you're not directly showing, but you're going a good way towards showing control over the illegal image. So you're sort of going part of the way towards proving possession, which is ultimately the crime, by admitting that the passcode if it's a contraband case.
Okay, so here's a question, and this isn't in the article, so if this is too weird, but it seems like you have these rules, and there's an evidence case and a contraband case. But what if? How do you advise, or what do you how do you argue if your client, and this confidentially because you're a lawyer and you can't be required to disclose it, but your client is being investigated for, say, some type of fraud, and they just want records. The government has seized the laptop, so they're looking for evidence. So it looks like an evidence case, but that there's maybe something that you're not allowed to possess simply on that that computer, right? Like there's child pornography on that computer, and are you just stuck? Is the government, so if they win and they can get it because it's just evidence, and then somehow they come across that child pornography, can you down the road do something else to try and do that? And I realize we've strayed into the Fourth Amendment here, but this is, the advanced round. So what, when these neat categories sort of break down, and what becomes like an evidence case turns into a contraband case.
Right. Absolutely. So great question about how to apply this. I can think of a couple ways it could be done. One would be you would just look to the probable cause required to search the device. So this is almost always going to occur in cases where there's a search warrant needed and the government is basically looking for help to carry out the search warrant. And so the government will have had to establish probable cause to believe there's evidence of a crime. And so one way of doing it is to say you can do the contraband evidence distinction based on what probable cause is. But there are situations, as you mentioned, where the government's probable cause will be for one, but it may be that there's evidence of the other. And I think this really gets into a broader Fourth Amendment question of what do you do with the scope of computer searches, because computer searches themselves can be really broad. And in the Fourth Amendment setting, I've argued that the Fourth Amendment should be interpreted in the digital evidence setting to have a use restriction, where basically the government, upon getting probable cause to search a computer for some data, can search anywhere on the device for that data. No limits as to where they can search, but they're not allowed to use the rest of the stuff that's on the device that might be evidence of crime. And this usually ends up sort of being labeled the plain view exception, where government searches for one thing, they're allowed to get anything else, take anything else that they come across. And so I have a separate article that says basically that you need to have a different rule for that in the digital evidence setting, because the dynamics of digital searches are so different from the dynamic of physical searches that you can't have the plain view exception operate in the same way. So, if you take those pieces together and you say it should be based on the warrant and there should be a use restriction where only that information can be covered, that would be an answer to that. But that's combining several totally unrelated cases.
It's multiple law review articles, but I mean, it's eminently practical, right? Because these things cannot be cabined ultimately in the real world. These things all kind of play together, and it sounds like, at least when it comes to the sort of contents of someone's brain, like this password, you must disclose it or something. The digital physical piece and the way technology has changed doesn't affect that much, because it's sort of unlocking in a different way. But something like what can you see in a doctrine like plain view is sort of, wow, there's a lot, right? We're all walking around with these computers in our things that are talking to boxes in the sky and telling us, where to get, Chinese food or something. So there's all this information. There was a question before we get to the last part of it. There was a question about warrants that we just want to address from the thing. So when this is kind of Fourth Amendment-y, but are multiple warrants needed? So let's talk about this guy it's going to be a guy typically. So that is being investigated for fraud. And then there's this other thing. And let's say they get the laptop, they are able to make him disclose his password. They're looking for the records. And then they see an image file that the file name is something like child pornography. But they can't open it, right? The name is there, but the contents are encrypted or something like that. Would they need another warrant now that this has changed? Can they just kind of compel, the opening of that too, or do you need something else?
So from a Fourth Amendment standpoint, courts have really struggled with this question, and there's some disagreement. There's a lower court split between some courts that say you take an objective view, which is basically it's on the device, and even if it has a name that suggests that it's records of some other crime, you can still open the file, because that's, when you're looking for digital evidence, you can look anywhere. And then other court, the 10th Circuit in particular, has suggested a subjective view, where you ask, was the officer subjectively looking for the stuff within the scope of the warrant, or was the officer subjectively, basically, did they abandon the search for what was in the warrant and instead only start looking for evidence of this unrelated crime? So courts are struggling with that. And then the Oregon Supreme Court has adopted the rule that I had talked about, the use restriction idea. So it's under the state constitution. So the Oregon state constitution has been interpreted to only allow the evidence described in the warrant. And if there's they can search the entire device, they can open every file, but they're just not allowed to use or disclose the files relating to other offenses. So this is something that this is a Supreme Court case in like 10 years or something like that. It'll take a while, I think, for this to really. Courts are really they're all over the map on this sort of question of how to limit computer searches is really hard.
Right. Well, and you're on the case, though, and it sounds like some of these law review articles, the courts are finding very helpful guidance. Let's then finish, right, on the, so on this other issue of entering passwords. So this is, and I find this is fascinating because I had to just make sure I understood. So one is tell us your password. And that is kind of, you're making me disclose the contents of my mind. And that is a sort of Fifth Amendment problem if that will sort of then incriminate me. Fine. Now, entering a password, I guess the argument is different. So the government would say, we're going to foreclose your Fifth Amendment objection by saying, you don't have to tell us your password. You don't have to give us the contents of your mind. Instead, we just want you to do this thing, move your fingers a certain way, and enter the password. And there's not a Fifth Amendment problem, says the government, because we're not compelling you to testify against yourself. You're just moving stuff around, and we promise not to look or log your keystrokes or anything like that. Do we have any help from the Burr trial, at least on original meaning or original law on this issue?
Yeah, so this is one where I think it depends on which analogy you find most persuasive. So we've got two different legal rules that might apply in that situation. One, it turns out there was a common law rule that you couldn't subpoena order a suspect to hand over their records. And so this actually was a causal rule. You couldn't go to the suspect. You can go to the defendant and say, hand this over. And so one way of thinking about it is maybe making a suspect or defendant enter in their password is like making them hand over the contents. Maybe it's kind of like a subpoena, which under the common law rule would seem to be barred. Now, the U.S. Supreme Court has not adopted that common law rule, and if they did adopt it, that's significant, like way beyond entering cell phone passwords. That's like a sea change in practice in terms of subpoena laws. But it seems to have been the common law rule that you couldn't get a defendant to hand over documents at the time. So that's one possibility. Another possibility is you could analogize entering in a password to just disclosing the password. Because that's ultimately, it's sort of practically speaking the same sort of thing. And this is just a battle of analogies. It's like there's a new fact, which is the new fact is you're entering it in, and then there are two old rules, and which version of the facts do you think most accurately captures the analogy? There's no right or wrong answer. It's just different ways of looking at it. So I ultimately say there's one rule for disclosing the password, and then it's potentially harder for the government to get them to enter in the password because it touches on this common law rule. And it was really interesting. I had no idea about this history until I got here. Until I was working on this. A common law, there was the idea of a witness, and a witness was a neutral third party who had no stake in the case. And a defendant could not be a witness because the defendant had an obvious stake in the case. So there were separate evidence rules with defendants than existed for witnesses. In fact, if you look at these old treatises, the first part of these evidence treatises is like, what is a witness? There are very specific rules on who could be a witness. And so I think at common law, you'd have a really different, you'd be like, wait a minute, this person's a defendant, not a witness. And so you'd have to ask yourself, do you stick with that? And do you apply the common law rule or not? There's all sorts of conceptual questions that would go along with kind of transferring all of these pieces, which the Supreme Court may or may not want to do. That's a lot to change.
Well, and I know we're running short, so let me try and bring this to then the, like predictive stuff, not the, useless kinds of things, but it sounds like history in this case, and in terms of history of law, can actually be useful. Knowing the exact ways in which it will plug into current controversies can be hard. But it sounds like perhaps maybe that the courts in some ways are opportunistic in that if the current doctrine is working okay, they might not need to go back. They might say, look, this is stable, equilibrium, but then something comes in to alter that. It might be a change in technology. It might be, there might be just all sorts of things. And that perhaps the history can then help us, ground us right, in reaching a new equilibrium. And those of you who haven't read all of Oren's articles, I will tell you that what I just mentioned there was a shout out to another Harvard Law Review article of Oren's. And at the John Marshall Center, Oren, we are so grateful for this deep dive that you did. And I know, we can't do a WWJMD all the time, right? What would John Marshall do? But it sounds like actually this is an area where, at least predictively, do we think the Burr trial will be cited sometime in the next 10 years or so by the Supreme Court of the United States?
Well, Chief Justice Roberts relied heavily on the Burr case recently. And in fact, he went into such glorious detail. It was clear he's also a legal history nerd. So he got so into it. I was thinking like, oh boy, he's gonna love the self-incrimination part. I think it's quite plausible that this will be a part of the debate when the U.S. Supreme Court gets it. And the reason why, Justice Gorsuch and Justice Thomas have both said in concurring or dissenting opinions that they think current Fifth Amendment doctrine on compelled acts needs to be rethought along the lines of the original public meaning of the Fifth Amendment. So both of them have already gone on record saying the compelled act part of this, there's this whole doctrine that we basically applies, lower courts have been struggling to apply to compelled entry of the passcode. And they've already said, we need to rethink this. And so I think they're naturally going to want to know, well, what's the history here? And it just so happens because not only do we have Chief Justice Marshall's opinion, but we have the transcript of the hours of debate to know exactly the context of that opinion. And it's this incredibly rich history, including all the citations to all of the materials that they had. We just happened to have it because it was such a high profile issue in this trial. So sometimes the history actually does provide like fairly detailed answers. How to apply it is going to be hard, but sometimes it does. Other times it doesn't. I have a Fourth Amendment article on the original meaning of searches and seizures, or searches in particular, in which I say basically like there wasn't anything on this. No one cared about this question. It just didn't come up, and here's why it didn't come up. And so there are a range of possible answers, and here's the range, and you can't do that much with it. But sometimes you can. And so this is, I think, one of those rare cases where actually there's a pretty rich history that I think I hope at least the justices are interested in, and they can go in different directions once they get there.
Well, John Marshall, Harvard Law Review, eventual Supreme Court case. It sounds like a triple. And then when there's a citation in the Supreme Court to Kerr on John Marshall, that will be our grand slam. So thank you so much, Oren. And we hope to welcome you back to the John Marshall Center. And thank you all for joining us this afternoon. And I'll toss it over to Caroline now to take us out.
Thanks so much, Kevin. And thank you both, Professor Walsh and Professor Kerr. Really just a fantastic conversation. Thank you to all of our audience members for tuning in this afternoon. It is so great to have those of you in the audience. And we would like to remind you again, just to visit our website. I'm going to plug both a survey link and a link to our membership portal on the website. So if you're interested in sort of staying in the loop of things that are happening at the John Marshall Center, that is the best way to do that. So thanks again to both of our panelists for participating this afternoon, and to you, the audience, for joining us. And we'll be signing off now from the Marshall Scholar Series. Thanks so much.